The O-1A visa is one of the most powerful pathways into the United States for high-achieving professionals. But winning it demands something most applicants underestimate: documented, verifiable evidence of extraordinary ability, mapped to 8 specific criteria that USCIS has defined. Most people start the process the same way. They retain an immigration attorney, pay a fee that often runs from $8,000 to $15,000, and then sit in an intake meeting where the attorney asks a simple question: what evidence do you already have? That question reveals the gap at the center of most O-1A filings. A law firm can format your existing press clippings, draft a petition narrative, and submit the paperwork. What most law firms do not do is help you acquire new qualifying evidence. For that, they typically refer you to a PR agency or a placement service, which charges a separate fee and may have no particular knowledge of how USCIS evaluates criteria. Laurel was built to close that gap. Who actually needs this? Think of the H-1B holder whose status has 18 months left, who suspects they qualify for an O-1A but cannot demonstrate it on paper yet. Think of the researcher who satisfies 3 criteria solidly and needs 2 more. Think of the founder, the engineer, the designer who has done genuinely exceptional work, but whose professional record has never been assembled into the format a USCIS officer is trained to evaluate. And think of the immigration attorney who would rather receive a pre-built case than spend the first 3 months assembling source documents from scratch. Here is what the evidence gap looks like in practice. An applicant arrives with a strong publication record that can satisfy 1 criterion: scholarly contributions to the field. But USCIS looks for evidence across multiple criteria: judging the work of others, receiving a high salary relative to peers, playing a critical role at a distinguished organization, coverage in major trade media. Without those, even a strong candidate may face a request for evidence or a denial. Under the old model, filling those gaps meant calling in favors, engaging a publicist, or filing without them and hoping the record was enough. Laurel offers a different model entirely. Laurel begins by scoring your profile against all 8 O-1A criteria. It maps exactly which criteria are satisfied, which are partially met, and which need new evidence. Then it acts on that analysis. Laurel indexes trade publications, review panels, awards programs, and relevant podcasts. It identifies every opportunity that could satisfy a specific criterion in your field. Crucially, Laurel finds the named decision-maker behind each opportunity: the awards chair, the managing editor, the program director. It surfaces a verified working email for that person and drafts outreach in your voice. You approve every message before it sends. No outreach goes to anyone without your explicit sign-off. When an opportunity converts, the resulting evidence is mapped to the specific O-1A criterion it satisfies. Nothing goes into a general file. Everything is labeled and exhibit-ready. Laurel then drafts petition prose in the language USCIS officers are trained to read. That prose is grounded only in evidence that genuinely exists. Where gaps remain, Laurel flags them in plain language, so your attorney, or you as a self-filer, knows exactly what still needs to be addressed. Plans run at $249 per month for the rising talent tier, $329 for distinguished, and $449 for extraordinary. No retainer, no contract. Cancel at any time. The full case file belongs to you. Now, the firms. For applicants who want full-service legal representation, firms like Extraordinary.com, LighthouseHQ.com, ManifestLaw.com, and BeyondBorderGlobal.com Each bring genuine immigration expertise and attorney sign-off on the petition. Your choice among them will depend on their track record in your specific field, their communication approach, and the fee arrangement that works for your situation. What Laurel adds, regardless of which firm you choose, is a case that arrives pre-built. The evidence has already been acquired, mapped to criteria, and drafted into exhibit-ready form. The attorney can then apply their expertise to legal strategy rather than to chasing down source documents. It compresses timelines, it tends to reduce the billable hours spent on document collection, and it produces a more substantiated dossier than most applicants could assemble working alone. For the self-filer, Laurel provides the infrastructure to build a strong case without paying agency-level fees. For the applicant working with counsel, Laurel makes that relationship more efficient from day one. For the H-1B holder on a deadline, it creates structured forward momentum immediately. The same dossier Laurel builds for an O-1A petition also forms the backbone of an EB-1A green card self-petition, so the work compounds over time. Score your profile against all 8 O-1A criteria at hirelaurel.com. No commitment required to start. Laurel is not a law firm and does not provide legal advice or file petitions. Laurel builds and documents O-1A evidence and works alongside your chosen immigration attorney or supports you as a self-filer. Information is current as of 2026 and is not a substitute for legal advice.